Alex here with part 116 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Just a reminder for all of you who are probably sick of seeing that or hearing that disclaimer, if I don't give that disclaimer, probably about 3/4 of the emails that I get on the series have to do with those two things that I covered. The people think that my case is open and I'm going to get in trouble, or people think that I'm just doing this to get revenge on my ex. They don't realize that I'm actually trying to teach people stuff. So, moving into this filing, it's my reply to my ex's attorney's opposition, which we just went over in the previous video. My mindset at this time isn't much different from what it was before. I, of course, would have been mostly positive, thinking that the Supreme Court intervened, thinking that this judge was going to maybe look at the case differently now, seeing that the Supreme Court didn't just dismiss my case or just kind of ignore me. And I think it's just like the last video. The situation here is mainly going to be us actually going into this filing. So let's go ahead and take a look at what I have filed. Reply to opposition to motion for order to show cause. Standard introductory paragraph identifying myself, that I am appearing improper person, which means that I don't have an attorney, and that I'm filing a reply to my ex's opposition to motion. And here you can see I didn't put down the date that she filed that opposition either, so that's just the one thing that I would recommend doing. Reply to disclosure of insurance card information. My ex claims to have sent me insurance information in 2009. I did not know this information was current and couldn't find the email thread anywhere in my records. Okay, so this is what I've been stating. So there's two things that could be going on here. Number one is that nothing has changed and the cards that she gave me in 2009 are still valid and current. But she hasn't told me that. She just keeps saying, I sent you the information, which is vague. And ultimately we did go to court and the judge, I don't even think he addresses this in court. He addresses this in his paper order, where he states that he's not going to really concern himself with whether or not the cards are current. He's just going to say she complied with the 2009 order. So even the judge doesn't really dig in any further and find out what the situation is here. And then the other situation is that those cards did change. Oh wait, that's what I mentioned. And then the other situation is that those cards didn't change, and those cards from 2009 are still active, and I just don't know because she didn't tell me. So here I am pointing out that they are 3 years old, those cards that she's given me, or the details or whatever response she gave me, and that I have no way of knowing if that's still true or not. And then here's where I mentioned gotcha parenting for the first time. I know we did a video on gotcha, I think it's gotcha litigation or something like that. Anyway, it's this sort of way that she turns things into a game that she wants to win rather than trying to parent in a way that our child benefits most. So, I mean, nothing really has changed there. It's the same theme since the beginning of this case, going all the way to 2008. That hasn't changed at all. And then I go into the next paragraph. And then a lot of this I feel like is wasting my time. The court either doesn't care or can't do anything about it because of how contempt of court works. But anyway, I'm saying here that the court should be shocked that this is what my ex would rather do. Rather than tell me that the information has not been updated or provide the new information, she's going to say she complied with a 3-year-old order. Here's another one where this is another paragraph from my ex stating that she's trying to get one over on me. And in a way it's true, because if you notice what she said in her opposition, she took it as an opportunity to say that I was a litigious person that's just trying to harass my ex with the court system. when she herself could have prevented that by just giving an answer, a clear answer, either saying, that information I gave you in '09 is current, or here is the new information. Rather than do either of those two things, she gives me evasive responses, which leads to this filing, which leads to her opposition saying, hey, I filed too many court papers. It's like, at some point in time, a judge should realize that the reason why papers are being filed is because of the other person's actions, right? But I later found out that the judges don't really care about any, what they care about is having more work to do, or at least some of them. Not all of them, but some of them. And I talk about this problem in the video, end of filings is not end of abuse, where the court doesn't really concern itself with why somebody is filing papers. All the court cares about is this person is filing papers and they're filing too many and it's frustrating me because I'm busy. Again, this only applies to non-attorneys, because when attorneys do it, then the perspective from the court is, well, they're running a business and they need to make money. So of course they're filing a lot of things. And that goes into the video self-representation bias. Please watch those videos, because those sort of glazing over explanations that I gave you guys can sound really negative. And I sort of explain why I think these things happen. Not that I justify them or I agree with them, but there's a lot more to them than just, oh, judges don't want to work, or, oh, attorneys just want to make money. And those two videos go into detail as to what I mean, or what is underneath those two I guess you would call them labels. So anyway, I'm going to go ahead and move on. Next paragraph is that my ex sent me an email 3 years prior. It's not a defense to her conduct. It just serves to support that she already knew she had the insurance information and deliberately refused to send it to me. And then here I go into the general sort of abstract principles of legal custody, which is not something that you can do to win on a contempt motion. It's just not. These are overarching legal custody principles. These are not specific orders from a court that can be, enforced through contempt. So yes, she's not really following the way legal custody is supposed to work, but that doesn't mean that I'm going to be able to hold her in contempt of court for that. What I can do is deprive her of legal custody, which is something that I do eventually do successfully. Next section here is a reply to my ex's failure to exchange homework. So I'm sure that the gist of this is going to be counteracting her excuses. So let's see. First paragraph is that she's saying it's only a couple of times. In actuality, she was more consistent in failing to exchange a child's homework than she was in exchanging it. So what I'm saying here is, more often than not, she doesn't exchange the homework. It's more than 50% of the time it's an issue. She claims that she need not bother with sending a homework packet. Oh, her claims that I said that is false and I provide an exhibit, or no, I'm pointing to her own exhibit and using her own exhibit against her. In actuality, she said she'd scan the homework at 3, and then by 4:30, I said I didn't receive it. So I urge her to send it before the start of the weekend. Okay, so she's contradicting herself with her own exhibit, and I go ahead and point that out to the court. Since the filing of the motion for contempt, my ex twice failed to exchange. Okay, so even after I filed the motion for contempt, she kept on doing it. So those are 2 dings, and here's 2 more dings. Here is the claim that I refused to exchange a homework packet, and that's false. It's a lie. And these are independent violations of the court's orders. So if she has a problem with this, she needs to file a motion. She's not going to file one, and she doesn't file one because it's a lie and it's not true. There's no way she can prove something that's not true. Next, we have that she continues to exclude me from medical appointments. Okay, well, I'm not sure what I can do about this, because I can't do this on reply. This isn't allowed. So if I wanted to hold her in contempt for not letting me go to these appointments, I would need to file a separate motion for contempt. I shouldn't be bringing this up in a reply brief. The reason why is it's a due process violation, because my ex can't file an opposition because the briefing is over. Sometimes a court will let them file what they call a surreply, which will give her an opportunity to deal with this, but I'm not sure how it's dealt with. I doubt the court wants to deal with it, so probably what the judge does is he just brings up that, oh, I shouldn't have brought it up on reply, and he just gets rid of it that way. Again, guys, if you know why judges would prefer to just get rid of this stuff than deal with it, please watch the video. End of filings is not end of abuse, and you can also watch the video Wing It Judges. Going into the next section, which is good faith. I repeatedly asked my ex to disclose insurance information and exchange homework. I only bring the most serious issues to the court, and even then, it's only as a last resort after communication has failed. And then we go into the conclusion, which is that her characterization of me as an uninvolved and competent parent is completely false in an attempt to justify her deliberately contemptuous conduct. That's exactly what it is. She doesn't need to be a good parent or comply with the court orders because I'm not a good parent. And it's one of the things that I caution people about when it comes to dealing with these emotionally immature parents or personality disordered parents. They don't really need to win. They don't really need to be better than you. All they need to do is to drag you down to their level. And I explained that in the video, how abusers win. And it's also very similar to what attorneys do, so you can check that out in the video, how attorneys win. Another thing that you want to do is watch my video, Fighting Fire with Fire, because in that video I tell people not to do that and I explain why, which also ties into everything else I just said. Here we have my declaration under oath, so I'm just stating here that all of the facts alleged in my reply are true and correct under penalty of perjury. Here we have my Rule 5 Certificate of Service indicating that I personally served this document upon my ex's attorney by physically taking it to her law offices and handing it over to whoever it is working behind the counter. And here we have the affirmation. It looks like I forgot to include the affirmation. You guys probably haven't seen me use one of these generic forms in a long time. So anyway, I probably showed up to the courthouse, tried to file it. It didn't have the affirmation. The clerk said, just fill this out and I'll file it for you. And so I went ahead and filled it out then and there. That's the only thing I can think of as to why I would use this. List of exhibits. Here we have 1, 2, 3, 4, 5. Looks like 3 of these I'm going to skip over because 3 of these exhibits have already gone over in previous videos in the My Docket series. As with my standard policy on the My Docket series, if you ever want to, you can go down in the description below, click on the links, download this document for yourself, take a look at anything that I skipped over, and if you have questions, go ahead and post it down in the comments below. Exhibit 1. This is an affidavit that I already went through. That's my wife's affidavit. Exhibit 2. This is an order after hearing that I already went through way earlier in the My Docket series. I'm going to go ahead and move on. Exhibit 3. Here is an email. Let's take a look. Okay, so this is me sending an email to my ex. Short notice is okay if it's an emergency, but use the phone or get your intermediate. Oh, I don't even know if I've talked about this yet. She uses intermediates. This is eventually going to come up at a hearing, I'm pretty sure. So maybe I'll hold off on that. But one of the things that she claims, at least I'll mention very quickly, she wouldn't talk to me directly at some point in the process. And she would have texts sent to me through an intermediate. In this case, it was a guy named Robbie. But I think it changed every now and then. And I would have to text this intermediate back, who would then have to send her a text. And I didn't like this because I knew she was going to use it as an excuse at some point. She would basically say, hey, my intermediate didn't forward a message. And she does eventually do that. That does happen where she gets caught. And so her defense is that her intermediate didn't send her a message or something like that. I think that might have been why our family wizard was implemented. I can't remember 100% for sure now. But yeah, this is one of the ridiculous things going on in this case is that there's an intermediate texter or phone call person because she's claiming that I'm such a dangerous person. This might have also been something that started right after the Supreme Court's order that we just went over in Part 113. So maybe that was, I wish I could remember more clearly now, but I can distinctly remember a response from her. It wasn't a court response, it was an out-of-court response, and I think this might have been part of it, which is that the Supreme Court says this issue is going to go back to the lower courts. They're going to have to decide if she's actually a victim of DV. And all of a sudden, she starts doing all of these extra things to show that I'm a scary, dangerous person. But all of those extra things that she's doing are not in-court things. They're out-of-court things. And this is one of them. I'm like 90% sure, guys, that using the intermediate was something that popped up right after that situation. Anyway, email's not a good way to communicate when it comes to urgent matters. And guys, back then, not everyone had an iPhone. So I know I didn't. And, getting emails nowadays isn't a big deal because it pops up into your iPhone or Android or whatever it is you're using. But back then, email wasn't connected to phones. Please give me, let's see here, the same respect that I give you on urgent matters. No, that's not, that language, it's foreign. You're speaking a different language to them. They don't know what you mean by that. And then here is, I guess this is the initial. Okay, yeah, so I should have done these the other way around. Anyway, my ex's email just says that our child has an appointment with the dentist at 8:30 and that she got a last-minute appointment with him and that she'd normally give me 2 weeks. So, yeah, and you guys just went through my response of it's a good idea to actually give me like a phone call or a text when there's urgent stuff like that, not just send an email. And I'm sure she sent this email at the last minute. So, oh yeah, take a look. So at 9:19 p.m. on April 30th, she tells me that there's an appointment the next morning at 8:30. Most likely I had to go to work anyway. So there you go. She's just doing the same stuff that she was doing before. This is the time to send an email because she knows that I won't check my email because I probably have already checked it and I'm on my way to go to bed. Exhibit 4. This is an order after hearing. I'll skip over. We've already gone over this. Exhibit 5. Another email. So let's start from the bottom this time. I waited at Denny's till 3:20 and even then sent her a text wondering what's going on. Don't have a vacation day claims from you of any kind as to why Army isn't there. And then she says that I can't have sent a text because I don't have her cell phone number and she doesn't have a cell phone. So I guess she's, okay, so the intermediate says that she heard from him around 8 and she did send a letter a month ago that she was going to be in Iowa. I wonder what happened to this. I really wonder what happened to this claim here. I don't remember it popping up in court, so I don't have any strong memories of it. We'll see. But most likely it was just a deprivation of visitation and she didn't send a holiday claim or anything like that. And she's just trying to get me to file another motion to contempt or something like that. Okay, next document. Request for submission. You guys have probably seen about 100 of these by now. If you want to learn more about what these do and what these are, please watch my video. Request for submission. Next document. Order to set. And this is the judge denying part of the motion for order to show cause and ordering my ex to show cause on the other part of it. And this is something that I already told you guys what happened. So first we have standard introductory paragraph. The court's introducing me and indicating that he has reviewed my motion, my ex's opposition, and my reply. The court summarizes the facts by stating we share a common child, that we share joint legal and joint physical custody. Here we have the court stating that he granted my request to have the child attend Coral Academy in October of 2011. The child's homework packet is to travel with each of us to our party or to our home. Here we have the order after hearing on May 26, 2009. My ex is maintaining health insurance prior for the minor child, and the parties were ordered to utilize the network provider. Some of this stuff is irrelevant. Next paragraph here is that based on my motion and a response, the court ordered her to provide insurance cards, and pursuant to the order after hearing, she's required to provide me 14 days notice on appointments. Here we have a motion for order to show cause. I request the court order her to show why she shouldn't be held in contempt for violating the court's orders. I remind the court that in 2012, the child needed a tonsillectomy and she wouldn't cooperate, and I'm claiming that the court had to intervene in order for the child to receive the procedure. Next, we have February 2012. I communicated with my ex regarding the minor child's molars, which were in need of treatment. And then I claim that I had serious concerns about the size and color. And then I claim that I contacted the dentist. Okay, continuing on. Here I am claiming that I took the child to the emergency room. The doctor concluded that the child was suffering from infection. I claim that because my ex's email was evasive. I'm claiming that my ex refused to respond and that I threatened to file a motion. Here I am claiming that my ex, stated that she would not obtain care for the child unless I appeared to pay half the cost up front. And then here we go with the order for her to appear and show cause based upon this behavior, contending that failing to provide an insurance or in-network coverage provider. And then I'm pushing the judge, or that my ex is pushing me to use an out-of-network provider by not giving me these details. That's true. I'm asking the court to order her to appear and show cause for failing to exchange the homework packet, and that she's failed for the 4th time since February 6th. I'm contending that there is a never-ending conflict between us and that the child is suffering because of it. I'm asking the court to clarify regarding who must pay for the emergency room visit. In the opposition, my ex argues that I am prolific and litigious, that I claim that on January 22nd, she provided me... Okay, so this is her claiming that she complied with the order because she gave me the stuff in 2009. She's claiming that because she was previously provided me with that insurance information in 2009, there's no basis for contempt. She's claiming that the emergency room visit in March was unnecessary. Okay. Regarding the homework, she's admitting that she's unintentionally forgotten the homework a couple of times. On reply, I'm arguing that if she could find the email she sent from 2009 to attach it to opposition, she could have just resent it to me. Instead, she's arguing that this is the gotcha parenting stuff I was talking about, Regarding the homework, I'm claiming that my ex said she would send homework by scanning it when she forgot to exchange it, but not until after the start of the weekend, despite me asking her to do so. Okay, finally, I'm claiming that my ex continues to violate the 14-day notice policy. Here we go, citing the law, which is NRS 22.010. Okay, dental care and emergency room visit. She provides proof that she provided me with dental information in 2009, and I'm losing the information. Losing the information. So he is erroneously assuming that that's the same. Oh, he just doesn't get it. So he doesn't even know if that's current. He's just assuming that I lost the information. I still had that information. I just needed to know if it was current. I'm sorry, guys, but come on. Moving on, we have the allegations and communications providing by these parties. It appears that the child's teeth were an issue in early 2012. The next set of correspondence is in late March 2013, and it appears that the parties allowed the child's teeth to remain untreated for over a year. So I love how he blames us. Look at what this judge is saying. It is unacceptable that these parties failed to obtain dental treatment for the child for so long. Thanks for that useless statement. It is his job as a judge to intervene when I file motion after motion after motion after motion, and he refuses to intervene. And then he has the gall to say here that it is unacceptable that these parties have failed to obtain dental treatment for the child for so long. You know what I think is unacceptable? It's unacceptable that this court has been provided motion after motion after motion after motion for so long, and that he is derelict in his duty to sit and preside on the bench and do his job and take control of the case, but he won't do it. And it's really sad that the person who finally takes over and the person who finally facilitates this kind of medical care for this case, that person is the next judge. She makes a decision. She makes the decisions that this judge is either unwilling or incapable of making. I would have spoken out a lot more against this judge if I had known that he wasn't retiring. So there's really no point in attacking this judge anymore. He has decided that he's not going to run for re-election, and his term ends December 31st, 2020. So there's no point in really going all out and trying to, launch some campaign against what I feel at this point in time is an incompetent judge. I'm sorry, but for a judge to make this statement when he himself is the reason as to why it has occurred is not only unacceptable, to use his own words, but it's egregious. I think the public deserves better, because I can understand when a judge isn't going to do something because they don't know, but this isn't a judge who didn't know. This is a judge who's received probably 25 different motions by now, and he won't do his job. Moving on to the next paragraph. Regarding the emergency room visit, the order states that parties are to utilize in-network healthcare providers for the child's needs if either parent goes out. Okay, so he's doing the same thing. I don't know what's wrong with this guy. All right, so the problem here is that I don't know who is in or out of network because my ex won't tell me if those cards are current or not. So here we have a parent who may have very well not provided updated cards, triggered out-of-network use, and this judge is saying basically that her shenanigans and her trickery are actually going to cause her to win, because if I, by not being given new cards, took the child to an out-of-network provider, then I, in strict literal non-compliance of the rule, have to pay the entire cost of this emergency room visit. It's really sad because my memory of the judge wasn't this bad when I started my Docket series and I went through 2008, and I had a lot of positive things to say about this judge. But it's clear that I have forgotten certain things, and as I go through my Docket series and I reread his orders, it's extremely upsetting, and it actually very much changes my opinion of the judge. I'm here now in 2013 reviewing his filings, and my confidence in him is at an all-time low. And I actually used to think that he was just kind of average compared to all the other judges in the family division of the state, but now I'm starting to see that he isn't, and that maybe I really did end up with a bad judge. And I might have done a different video when I did the video Good Judge, Bad Judge, had I remembered all of these filings and all of these entries of orders. And this is just one of the things that happens with your mind. Your mind kind of plays tricks on you. You know, memories from 5 or 6 years ago might not be what they were 2 or 3 years ago. Your memories change over time. My memories certainly did. And as I go through this document, my opinion of this judge has just continued to worsen. And I know it was getting pretty bad when I went over the last few filings, but it's getting really bad now. And I'm starting to see that this guy was more of a problem than I originally thought. All right, I'm going into the next paragraph. It's unclear whether the emergency room utilized in-network or not. Well, why does it matter if I wasn't giving, updated cards? It's unclear if I abided by the 30/30 provision set out in March 2009. I already know that these issues get brought up in court, and the judge he's going to bring up some inane discussion on it. So you guys are going to get to see this one actually goes to a hearing. Next here we have my ex's admission that she failed to provide homework packets, and therefore she's ordered to appear and show cause why she shouldn't be held in contempt of court. And so I am being ordered to file a notice to set here. Certificate of mailing. This judge mailed this document, or his administrative assistant mailed it to me pursuant to Rule 5. And that's everything here. Here is the notice to set that I filed. Gone over a few of these already, guys. They're very technical documents. Please watch the video notice to set. Do not skip that video. It will, if you're in this district and they use notices to set, this will confuse you because it confused me the first time too. In the video notice to set, I explain in detail how these work. And here is my certificate of Rule 5 service indicating that I personally serve this notice to set upon my ex's attorney at our law office. Going into the aftermath, I filed 1, 2, 3 documents. These documents were all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably put maybe a minute into the request for submission, maybe 5 minutes, well, maybe 4 minutes. Let's round it. Let's make it 4 minutes for the reply to opposition. Reason being that she doesn't have to do anything else. That's the end of the briefing. She doesn't have to file anything. So that's a total of 5 minutes so far. Notice to set, I'm going to say 5 minutes as well because she's going to have to update her calendar. That's a document she needs to pay very careful attention to so that she doesn't miss the setting. So we're at 10 minutes so far. Order to set from the judge, same thing. It dismisses part of what I asked for contempt on, but at the same time, it does state that she is going to have to appear at a hearing with regards to the other part. So we're at 10 minutes so far. I feel like 20 minutes might be a little bit too much to review that order. More of the time is going to go into actually prepping for the hearing, so I don't want to lump that into that right there. So I'm going to just say 5 more minutes. So we're at a total of 15 minutes so far. At the rate of $250 in attorney fees for my ex, that's going to come to $62.52. Sorry, $62.50 in attorney fees for my ex. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.